Welcome back to Shaikhain. Today we shall discuss an important legal term that is called without prejudice, or someone can say without prejudice. What is the meaning of this legal term, how is to be used, and what is the importance of this legal term in our official documents or on the documents on the matters which are under negotiation. As per the Black Law Dictionary, it means without loss of any right or privilege. The basic meaning of the term without prejudice is that the statements made in the settlement of an existing dispute cannot be relied upon as evidence against the interest of the relevant party if negotiations fail and the parties then have to formally engage into disputes resolution procedures. In other words, if the party says something that might be considered as evidence against their interest, they cannot be prejudiced by it. If the parties later engage in arbitration or litigation or any other formal or informal procedure of dispute resolution. The main reason that the lawyers use this term is to encourage open and free discussion in the settlement of the disputes, with parties reassured that anything said might otherwise prejudice their interest can be used against them. This is thought to encourage resolution out of the court, which in turn reduces cost of all sides. Similarly, just because a statement has not been expressly communicated without prejudice doesn't mean that it will not qualify for protection. Again, the question is whether the statement has been made in the course of a genuine attempt to resolve an existing dispute. It is better, however, to err on the side of the caution and include without prejudice in the communications expressly. To sum up, these communications are protected by without prejudice privilege, meaning they are inadmissible in court and cannot be made the subject disclosure order in any proceeding.